GR number 81958, June 30th, 1988. Philippine Association of Service Exporters, Incorporated, Petitioner versus Han. Franklin M. Drilon as Secretary of Labor and Employment, and Tomas D. Achicazo as Administrator of the Philippine Overseas Employment Administration. Respondents. Topic: Police Power Facts. The petitioner, Philippine Association of Service Exporters, Incorporated, PASAE, a firm engaged principally in the recruitment of Filipino workers, male and female, for overseas placement, challenges the constitutional validity of Department Order No. 1, Series of 1988, of the Department of Labor and Employment, in the character of guidelines governing the temporary suspension of deployment of Filipino domestic and household workers, through petition for certiorari and prohibition. Specifically, the measure is assailed for discrimination against males or females, that it does not apply to all Filipino workers but only to domestic helpers and females with similar skills, and that it is violative of the right to travel. It is held likewise to be an invalid exercise of the lawmaking power, police power being legislative, and not executive, in character. On May 25, 1988, the Solicitor General, on behalf of the Respondent Secretary of Labor and Administrator of the Philippine Overseas Employment Administration, filed a comment informing the court that on March 8, 1988, the Respondent Labor Secretary lifted the deployment ban in the states of Iraq, Jordan, Qatar, Canada, Hong Kong, United States, Italy, Norway, Austria, and Switzerland. In submitting the validity of the challenging guidelines, the Solicitor General invokes the police power of the Philippine state. Issue: whether or not Department Order No. 1 is unconstitutional, it being an invalid exercise of the lawmaking power since police power is legislative and not executive in nature. Ruling: no. The concept of police power is well established in this jurisdiction. It has been defined as the state authority to enact legislation that may interfere with personal liberty or property in order to promote the general welfare. As defined, it consists of 1. An imposition of restraint upon liberty or property. 2. In order to foster the common good. It is not capable of an exact definition but has been, purposely, veiled in general terms to underscore its all-comprehensive embrace. As a general rule, official acts enjoy a presumed validity. In the absence of clear and convincing evidence to the contrary, the presumption logically stands. The petitioner has shown no satisfactory reason why the contested measure should be nullified. There is no question that Department Order No. 1 applies only to female contract workers, but it does not thereby make an undue discrimination between the sexes. It is well settled that equality before the law under the Constitution does not import a perfect identity of rights among all men and women. It admits of classifications, provided that 1. Such classifications rest on substantial distinctions. 2. They are germane to the purposes of the law. 3. They are not confined to existing conditions. And 4. They apply equally to all members of the same class. The court took judicial notice of the unhappy plight that has befallen our female labor force abroad, especially domestic servants, amid exploitative working conditions marked by, in not a few cases, physical and personal abuse. The sordid tales of maltreatment suffered by migrant Filipino workers, even rape and various forms of torture, confirmed by testimonies of returning workers, are compelling motives for urgent government action. As precisely the caretaker of constitutional rights, the court is called upon to protect victims of exploitation. In fulfilling that duty, The court sustains the government's efforts. There is also no merit in the contention that Department Order No. 1 constitutes an invalid exercise of legislative power. It is true that police power is the domain of the legislature, but it does not mean that such an authority may not be lawfully delegated. As we have mentioned, the Labor Code itself vests the Department of Labor and Employment with rulemaking powers in the enforcement whereof. In view of the foregoing, the petition was dismissed Lai Chijing, in behalf of other alien residents, corporations and partnerships adversely affected by RA 1180, Petitioner vs. Jamie Hernandez, Finance Secretary, Marcelino Sarmiento, City Treasurer of Manila. Respondents. Facts. 1. RA 1180 or the Act to regulate the retail business was passed by the Congress. In effect, it nationalizes the retail trade business. One of the provisions of this act is to prohibit persons, not citizens of the Philippines, and against associations, partnerships, or corporations the capital of which are not wholly owned by citizens of the Philippines, from engaging directly or indirectly in the retail trade. 2. Petitioner, for and in his own behalf and on behalf of other alien resident corporations and partnerships adversely affected by the provisions of Republic Act No. 1180, brought this action to obtain a judicial declaration that said act is unconstitutional, and to enjoin the Secretary of Finance and all other persons acting under him, particularly city and municipal treasurers, from enforcing its provisions. Petitioner attacks the constitutionality of the act, contending that it denies to alien residents the equal protection of the laws and deprives of their liberty and property without due process of law. 3. In answer, the Solicitor General and the Fiscal of the City of Manila contend that the act was passed in the valid exercise of the police power of the state, which exercise is authorized in the Constitution in the interest of national economic survival. Issue 1. RA 1180 is within the province of police power, thus making it constitutional. Ruling. Yes. The court is fully satisfied upon a consideration of all the facts and circumstances that the disputed law is not the product of racial hostility, prejudice or discrimination, but the expression of the legitimate desire and determination of the people, through their authorized representatives, to free the nation from the economic situation that has unfortunately been saddled upon it rightly or wrongly, to its disadvantage. The law is clearly in the interest of the public, nay of the national security itself, and indisputably falls within the scope of police power, through which and by which the state ensures its existence and security and the supreme welfare of its citizens. It has been said the police power is so far reaching in scope that it has become almost impossible to limit its sweep, as it derives its existence from the very existence of the state itself. It does not need to be expressed or defined in its scope. It is said to be coextensive with self-protection and survival, and as such it is the most positive and active of all governmental processes, the most essential, insistent and illimitable, especially is it so under a modern democratic framework where the demands of society and of nations have multiplied to almost unimaginable proportions. The field and scope of police power has become almost boundless, just as the fields of public interest and public welfare have become almost all-embracing and have transcended human foresight. Otherwise stated, as we cannot foresee the needs and demands of public interest and welfare in this constantly changing and progressive world, so we cannot delimit beforehand the extent or scope of police power by which and through which the state seeks to attain or achieve interest or welfare. So it is that Constitution do not define the scope or extent of the police power of the state. What they do is to set forth the limitations thereof. The most important of these are the Due Process Clause and the Equal Protection Clause. Gr. No. L 7859. December 22, 1955. Walter Lutz, as Judicial Administrator of the intestate estate of the deceased Antonio Jaime Ledesma, Plaintiff Appellant versus J. Antonio Araneta, as the Collector of Internal Revenue, Defendant Appellee. Facts: Walter Lutz, as Judicial Administrator of the intestate estate of Antonio Jaime Ledesma, sought to recover the sum of P14. 666.40 paid by the estate as taxes from the Commissioner under Section E of Commonwealth Act 567 or the Sugar Adjustment Act, alleging that such tax is unconstitutional as it levied for the aid and support of the sugar industry exclusively, which in plaintiff's opinion is not a public purpose for which a tax may be constitutionally levied. Issue: whether or not the tax imposition in the Commonwealth Act No. 567, Sugar Adjustment Act, is valid. Held: yes. The Supreme Court affirmed the decision of the RDC which costs against the appellant, upholding the constitutionality of CA No. 567. The tax is levied with a regulatory purpose, to provide means for the rehabilitation and stabilization of the threatened sugar industry. The act is primarily an exercise of police power and is not a pure exercise of taxing power, as sugar production is one of the great industries of the Philippines and its promotion, protection, and advancement redounds greatly to the general welfare. The legislature found that the general welfare demanded that the industry should be stabilized, and provided that the distribution of benefits had to sustain. Further, it cannot be said that the devotion of tax money to experimental stations to seek increase of efficiency in sugar production, utilization of byproducts, and solution of allied problems, as well as to the improvement of living and working conditions in sugar mills and plantations without any part of such money being channeled directly to private persons, constitute expenditure of tax money for private purposes. Hence, the tax is valid. GR number 78,742 July 14, 1989. Assoc. of Small Land Hours in the Phils Incorporated versus SEC. of Agrarian Reform. Facts: these are consolidated cases involving common legal questions including serious challenges to the constitutionality of several measures like EO number 228, PD number 27, Presidential Proclamation number 131, EO number 229 and RA number 6657 Comprehensive Agrarian Reform Law of 1988. In GR number 7977, the petitioners in the said case are questioning PD number 27 and EO numbers 228 and 229 on the grounds of separation of powers, equal protection, due process, and the constitutional limitation that no private property shall be taken for public use without just compensation. In GR number 79,310, the petitioners in this case claim that the power to provide for comprehensive agrarian reform program as provided in the Constitution is lodged in the Congress and not to the President. The petitioners also seek to prohibit the implementation of Proclamation number 131 and EO number 229. The petitioners contend that the taking of the property must be simultaneous with the payment of just compensation, which Sec. 5 of EO number 229 does not provide. In GR number 79,744, the petitioner alleges that EO numbers 228 and 229 were invalidly issued by the President and that the said EOs violate the constitutional provision that no private property shall be taken without due process or just compensation, which was denied to the petitioner. In GR number 78,742, petitioner claims that they are unable to enjoy their right of retention because they cannot eject their tenants due to the fact that the Department of Agrarian Reform DAR has not issued the implementing rules required under the said decree. The petitioners are therefore asking the Honorable Court for a writ of mandamus to compel the DAR to issue the said rules. Issue 1. The laws questioned are valid exercise of power of eminent domain. Ruling. Yes. There are traditional distinctions between the power of eminent domain and police power which logically preclude the application of both powers at the same time involving the same subject. The property condemned under police power is harmful or intended for harmful purposes, like a building on the verge of collapse, which needs to be demolished for public safety, or obscene materials, which should be destroyed in the interest of public morals. Under police power, the confiscation of such property is not compensable, unlike the taking done in the exercise of power of eminent domain, which requires the payment of just compensation to the owner. The petitions before the court present no knotty complication insofar as the question of compensable taking is concerned. There is an exercise of police power for the regulation of private property in accordance with the Constitution with regards to the extent that the laws in question merely prescribe the retention limits for the landowners. However, there is definitely a taking under power of eminent domain which payment of just compensation is imperative when in order to carry out the regulation, it is necessary to deprive such land now Gr. No. L. 63419 December 18, 1986 Lozano v. Martinez Course Topic: Police Power Facts. The constitutionality of Batas Pambansa Billing 22, Bouncing Check Law, is the sole issue presented by these petitions for decision. The petitioners contended that statute is unconstitutional being contrary to the constitutional provision forbidding imprisonment for debt. The said law punishes a person who makes or draws and issues any check on account for value, knowing at the time of issue that he does not have sufficient funds in or credit with the drawee bank, XXX, which aims to stop the practice of issuing checks that are worthless that causes injury to the public interest. They also contended that the statute runs counter to the inhibition in the Bill of Rights which states, "No person shall be imprisoned for debt or non-payment of a poll tax." They insist that what it punishes is the non-payment of the check and not the act of issuing it. The statute, it is claimed, is nothing more than a veiled device to coerce payment of a debt under the threat of penal sanction. Issue 1. Enactment of BP 22 repugnant of the constitutional inhibition against imprisonment for debt and therefore is an invalid exercise of police power. No. Ruling. Police power is a dynamic force that enables the state to meet the exigencies of changing times. The offense punished by BP 22 is the act of making and issuing a worthless check, not the non-payment of an obligation which the law punishes. The law is not intended or designed to coerce a debtor to pay his debt. The thrust of the law is to prohibit, under pain of penal sanctions, the making of worthless checks and putting them in circulation. Because of its deleterious effects on the public interest, the practice is proscribed by the law. The law punishes the act not as an offense against property, but an offense against public order. Hence, the enactment of BP 22 is a valid exercise of police power and is not in conflict with the constitutional inhibition against imprisonment for debt. The SE finds no valid ground to sustain the contention that BP 22 impairs freedom of contract. The freedom of contract which is constitutionally protected is freedom to enter lawful contracts. Contracts which contravene public policy are not lawful. Department of Education, Culture and Sports vs. San Diego Gr. number 89572 December 21, 1989 Facts. 1. Roberto Rey San Diego is a zoology graduate of the University of the East who wanted to pursue medical studies. However, he had taken the NMAT for a total of three times already and failed in each try. When he tried to take the NMAT the fourth time, His application was denied based on MEC's Order No. 12, S. 1972, which institutionalized the three-flunk rule, or that any college graduate who has failed the NMAT for 3 times is no longer eligible to take it too. San Diego filed a petition before the RTC of Valenzuela to challenge the three-flunk rule, saying that the same was a violation of his academic freedom and his right to have quality education. In his amended petition, he said the rule was violative of due process and equal protection. 3. San Diego was allowed to take the NMAT 4th time subject to the outcome of his petition. Judge Teresita Dizon Capulong of RTC Valenzuela granted his petition and declared the three-flunk rule invalid. Issues: whether or not the three-flunk rule is a legitimate exercise of police power. Yes. Ruling: the NMAT is a constitutionally sanctioned measure intended to limit the admission to medical schools only to those who have initially proved their competence and preparation for a medical education. It is the right and indeed the responsibility of the state to ensure that the medical profession is not infiltrated by incompetents to whom patients may unwarily entrust their lives and health. The three-flunk rule is intended to insulate the medical schools and ultimately the medical profession from the intrusion of those not qualified to be doctors. On police power: yes, police power is validly exercised if the interests of the public generally, as distinguished from those of a particular class, require the interference of the state, and b. the means employed are reasonably necessary to the attainment of the object sought to be accomplished and not unduly oppressive upon individuals. The subject of the challenged regulation is certainly within the ambit of the police power. It is the right and indeed the responsibility of the state to ensure that the medical profession is not infiltrated by incompetents to whom patients may unwarily entrust their lives and health. While every person is entitled to aspire to be a doctor, he does not have a constitutional right to be a doctor. This is true of any other calling in which the public interest is involved, and the closer the link, the longer the bridge to one's ambition. The state has the responsibility to harness its human resources and to see to it that they are not dissipated or, no less worse, not used at all. These resources must be applied in a manner that will best promote the common good while also giving the individual a sense of satisfaction. GR number 74457, March 20th, 1987. Petitioner: Restituto Wynor. Respondent: Intermediate Appellate Court. The Station Commander: Integrated National Police, Baratac Nuevo, Iloilo, and the Regional Director, Bureau of Animal Industry, Region IV, Iloilo City. Ponent: Cruz, J. Topic: Judicial Review. WHO may exercise power. This is a petition for review on certiorari seeking to annul and set aside the decision of the Regional Trial Court and the Intermediate Appellate Court to sustain the confiscation of the supersedeas bond upon non-production of the previously confiscated carabaos. Facts: petitioner had transported 6 carabaos in a pump boat from Masbate to Iloilo. The police station commander confiscated the said carabaos for violation of Executive Order No. 626A, which prohibits the interprovincial movement and the slaughtering of carabaos. Petitioner sued for recovery, and the RTC issued a writ of replevin upon filing of a supersedeas bond of $12,000. The RTC sustained the confiscation of the carabaos, and since they could no longer be produced, ordered the confiscation of the bond. The court also declined to rule on the constitutionality of the executive order as raised by the petitioner, for lack of authority and presumed validity. The petitioner appealed to the Intermediate Appellate Court, which affirmed the decision of the RTC. Hence, this petition issue, WN Executive Order No. 626A, is unconstitutional. Ruling: yes. To sum up then, we find that the challenged measure is an invalid exercise of the police power because the method employed to conserve the carabaos is not reasonably necessary to the purpose of the law and, worse, is unduly oppressive. Due process is violated because the owner of the property confiscated is denied the right to be heard in his defense and is immediately condemned and punished. The conferment on the administrative authorities of the power to adjudge the guilt of the supposed offender is a clear encroachment on judicial functions and militates against the doctrine of separation of powers. There is, finally, also an invalid delegation of legislative powers to the officers mentioned therein who are granted unlimited discretion in the distribution of the properties arbitrarily taken. For these reasons, we hereby declare Executive Order No. 626A unconstitutional. Wherefore, Executive Order No. 626A is hereby declared unconstitutional. Except as affirmed above, the decision of the Court of Appeals is reversed. The supersedious bond is cancelled and the amount thereof is ordered restored to the petitioner. No costs Gr. No. L. 34915 June 24, 1983 City Government of Quezon City and City Council of Quezon City. Petitioners. Versus Hone. Judge Vicente G. Iricta. Facts. A petition for review which seeks the reversal of the decision of the Court of First Instance of Rizal, Branch 18 declaring Section 9 of Ordinance No. 6118, S64, of the Quezon City Council null and void. Section 9 of Ordinance No. 6118, S64, at least 6% of the total area of the Memorial Park Cemetery shall be set aside for charity burial of deceased persons who are paupers and have been residents of Quezon City for at least 5 years prior to their death. To be determined by competent city authorities. The area so designated shall immediately be developed and should be open for operation not later than 6 months from the date of approval of the application. The Quezon City engineer notified Respondent Himley and Filipino, incorporated in writing that Section 9 of Ordinance No. 6118, S64 would be enforced. Respondent Himley and Filipino reacted by filing with the Court of First Instance of Rizal Branch 18 at Quezon City, a petition for declaratory relief, prohibition and mandamus with preliminary injunction SP Proc. No. Q 16002, seeking to annul Section 9 of the ordinance. The respondent court, therefore, rendered the decision declaring Section 9 of Ordinance No. 6118, S64 null and void. A motion for reconsideration having been denied, the city government and city council filed the instant petition. Petitioners argue that the taking of the respondent's property is a valid and reasonable exercise of police power and that the land is taken for a public use as it is intended for the burial ground of paupers. Issue: whether or not Section 9 of the ordinance in question is a valid exercise of police power. Held: no. The ordinance in question is not a valid exercise of police power. Section 9 cannot be justified under the power granted to Quezon City to tax, fix the license fee, and regulate such other business, trades, and occupation as may be established or practiced in the city. Subsection C, Sec 12, RA 537. The ordinance in question not only confiscates but also prohibits the operation of a memorial park cemetery, because under Section 13 of said ordinance, violation of the provision thereof is punishable with a fine and/or imprisonment, and that upon conviction thereof the permit to operate and maintain a private cemetery shall be revoked or cancelled. There is no reasonable relation between the setting aside of at least 6% of the total area of a private cemeteries for charity burial grounds of deceased paupers and the promotion of health, morals, good order, safety, or the general welfare of the people. The ordinance is actually a taking without compensation of a certain area from a private cemetery to benefit paupers who are charges of the municipal corporation. Instead of building or maintaining a public cemetery for this purpose, the city passes the burden to private cemeteries. Police power is defined by Freund as the power of promoting public welfare by restraining and regulating the use of liberty and property quoted in Political Law by Tanada and Carrion. V11, page 50. It is usually exerted in order to merely regulate the use and enjoyment of property of the owner. If he is deprived of his property outright, it is not taken for public use but rather to destroy in order to promote the general welfare. It seems to the court that Section 9 of Ordinance No. 6118, Series of 1964 of Quezon City is not a mere police regulation but an outright confiscation. It deprives a person of his private property without due process of law, nay, even without compensation. When the Local Government Code, Batas Pambansa BLG 337 provides in Section 177, Q, that a Sangguniang Panlungsod may provide for the burial of the dead in such place and in such manner as prescribed by law or ordinance, it simply authorizes the city to provide its own city-owned land or to buy or expropriate private properties, to construct public cemeteries. Wherefore, the petition for review is hereby dismissed. The decision of the respondent court is affirmed. Manila Memorial Park v. DSWD, GR 175356, December 3, 2013. Facts: RA 7432 was passed into law, amended by RA 9257. Granting senior citizens 20% discount on certain establishments. To implement the tax provisions of RA 9257, the Secretaries of DOF and DSWD issued its own rules and regulations. Hence, this petitioners assail the constitutionality of Sec 4 of RA 7432 and its IR insofar as these allow business establishments to claim the 20% discount given to senior citizens as a tax deduction. They are not questioning the 20% to senior citizen discount but only the tax deduction scheme. They posit that it contravenes Art. 3, Sec. 9 of the Constitution, which provides, private property shall not be taken for public use without just compensation. Respondents, on the other hand, maintain that the tax deduction scheme is a legitimate exercise of the state's police power. Issue 1. Whether the tax deduction scheme is a valid exercise of police power. 2. Whether the 20% senior citizen discount is an exercise of police power or eminent domain. Held. 1. Yes. The state, in promoting the health and welfare of a special group of citizens, can impose upon private establishments the burden of partly subsidizing a government program. The Senior Citizens Act was enacted primarily to maximize the contribution of senior citizens to nation building, and to grant benefits and privileges to them for their improvement and well-being as the state considers them an integral part of our society. The priority given to senior citizens finds its basis in the Constitution as set forth in the law itself. The law is a legitimate exercise of police power which, similar to the power of eminent domain, has general welfare for its object. It has been described as the most essential, insistent and the least limitable of powers, extending as it does to all the great public needs. It is power vested in the legislature by the Constitution to make, ordain, and establish all manner of wholesome and reasonable laws, statutes, and ordinances, either with penalties or without, not repugnant to the Constitution, as they shall judge to be for the good and welfare of the Commonwealth, and of the subjects of the same. For this reason, when the conditions so demand as determined by the legislature. Property rights must bow to the primacy of police power because property rights, though sheltered by due process, must yield to general welfare. Police power as an attribute to promote the common good would be diluted considerably if on the mere plea of petitioners that they will suffer loss of earnings and capital, the questioned provision is invalidated. Without sufficient proof that Sec. 4 of RA 9257 is arbitrary, and that the continued implementation of the same would be unconscionably detrimental to petitioners, the court will refrain from quashing a legislative act. 2. The 20% discount is a valid exercise of police power. Police power is the inherent power of the state to regulate or to restrain the use of liberty and property for public welfare. To be a valid exercise of police power, it must have a lawful subject or objective and a lawful method of accomplishing the goal. Eminent domain, on the other hand, is the inherent power of the state to take or appropriate private property for public use. The Constitution, however, requires that private property shall not be taken without due process of law and the payment of just compensation. It may not always be easy to determine whether a challenged governmental act is an exercise of police power or eminent domain. The judicious approach, therefore, is to look at the nature and effects of the challenged governmental act and decide on the basis thereof. The 20% discount is intended to improve the welfare of senior citizens who, at their age, are less likely to be gainfully employed, more prone to illnesses and other disabilities, and, thus, in need of subsidy in purchasing basic commodities. It serves to honor senior citizens who presumably spent their lives on contributing to the development and progress of the nation. In turn, the subject regulation affects the pricing, and, hence, the profitability of a private establishment. The subject regulation may be said to be similar to, but with substantial distinctions from, price control or rate of return on investment control laws, which are traditionally regarded as police power measures. Wilfredo Mosqueda v. Filipino Banana Growers and Exporters Association, PBGEA, GR number 189185, August 16, 2016. Facts. After several committee hearings and consultations with various stakeholders, the Sangguniang Panlungsod of Davao City enacted Ordinance Number 0309, Series of 2007, to impose a ban against aerial spraying as an agricultural practice by all agricultural entities within Davao City. The PBGEA, Davao Fruits Corporation, and Lapande Agricultural Land Development Corporation PBGEA, et al., filed their petition in the RDC to challenge the constitutionality of the ordinance. They alleged that the ordinance exemplified the unreasonable exercise of police power, violated the Equal Protection Clause, amounted to the confiscation of property without due process of law, and lacked publication pursuant to Section 511(6) of Republic Act No. 7160 on September 22, 2007, after trial. The RDC rendered judgment declaring Ordinance No. 309-307 valid and constitutional. The RDC opined that the City of Davao had validly exercised police power under the General Welfare Clause of the Local Government Code, that the ordinance, being based on a valid classification, was consistent with the Equal Protection Clause, that aerial spraying was distinct from other methods of pesticides application because it exposed the residents to a higher degree of health risk caused by aerial drift, and that the ordinance enjoyed the presumption of constitutionality, and could be invalidated only upon a clear showing that it had violated the Constitution. On January 9, 2009, the CA promulgated its assailed decision reversing the judgment of the RDC. It declared Section 5 of Ordinance No. 309-307 as void and unconstitutional for being unreasonable and oppressive. Hence, this petition. Issue 1. Ordinance No. 309-307 constitutes an invalid exercise of police power in imposing a ban on aerial spraying as an agricultural practice in Davao City under Section 5b. In decreeing a 3-month transition period to shift to other modes of pesticide application under Section 5 and c. In requiring the maintenance of the 30-meter buffer zone under Section 6 thereof in all agricultural lands in Davao City. Ruling. Yes. To be considered as a valid police power measure, an ordinance must pass a 2-pronged test, the formal, i.e., whether the ordinance is enacted within the corporate powers of the local government unit, and whether it is passed in accordance with the procedure prescribed by law, and the substantive, i.e., involving inherent merit, like the conformity of the ordinance with the limitations under the Constitution and the statutes, as well as with the requirements of fairness and reason, and its consistency with public policy. Ordinance No. 309-307 violates the Due Process Clause. A valid ordinance must not only be enacted within the corporate powers of the local government and passed according to the procedure prescribed by law. In order to declare it as a valid piece of local legislation, it must also comply with the following substantive requirements, namely, 1. It must not contravene the Constitution or any statute. 2. It must be fair, not oppressive. 3. It must not be partial or discriminatory. 4. It must not prohibit but may regulate trade. 5. It must be general and consistent with public policy. And 6. It must not be unreasonable. In the state's exercise of police power, the property rights of individuals may be subjected to restraints and burdens in order to fulfill the objectives of the government. A local government unit is considered to have properly exercised its police powers only if it satisfies the following requisites, to wit, 1. The interests of the public generally, as distinguished from those of a particular class, require the interference of the state, and 2. The means employed are reasonably necessary for the attainment of the object sought to be accomplished and not unduly oppressive. The first requirement refers to the Equal Protection Clause of the Constitution, the second, to the Due Process Clause of the Constitution. Substantive due process requires that a valid ordinance must have a sufficient justification for the government's action. This means that in exercising police power, the local government unit must not arbitrarily, whimsically or despotically enact the ordinance regardless of its salutary purpose. So long as the ordinance realistically serves a legitimate public purpose, and it employs means that are reasonably necessary to achieve that purpose without unduly oppressing the individuals regulated, the ordinance must survive a due process challenge.